Hi, this is Kelly with Broaddus Properties Group. We're doing a very special series. We'll probably be airing one of these videos per month, and this is a video. This is a series on estate planning. We will be talking to Ashley Debord from the Flagstaff Law Group, and she's going to be answering a couple questions a week that are really important to estate planning. I hope that you'll join us and enjoy these very helpful and informative videos. She's available to book a 15-minute consultation for free for any of you that are interested, and you can just go to her website, which she talks about at the end. So if someone says to you that I don't have a large estate, do I still need an estate plan? What would you tell them?
I would say you need a plan if you have anyone that you care about and you want to spare them the difficulty of having to navigate a court process at the height of a family crisis, such as in the event of your incapacity or after your death. You can imagine it's probably going to be one of the most difficult times emotionally that our loved ones are going to face, and they're really searching for a life raft in those moments. So your estate plan is really that life raft. It's something for them to hold on to when things are stormy and guide them to what needs to occur.
What if a family member who I would never want to be a guardian of my children, how do you protect your kids and make sure they go to who you want them to go to?
This can be a delicate question, and you'd be surprised that it comes up much more often than we may expect. But I think parents take a lot of care in selecting the guardians that they're entrusting their children with, and they want to be really confident in ensuring that those are the folks that are going to be able to serve and in the order that they've specified. But sometimes there are family dynamics where they worry there might be another family member that comes out of the woodwork who challenges those designations in court and tries to be overriding the parents' guardian designation. So, if that's a concern or a risk, I usually recommend clients go a step further and actually document the exclusion of guardians, which can be equally as important as documenting who they would choose to raise their children if they couldn't. So, and that doesn't have to be something that gets sent to the excluded person. Certainly there can be delicate family dynamics involved. So it can be something that remains confidential unless and until it's needed. But it is an important practice if there's any concern that your designations would be challenged and you want to make absolutely clear that you've considered that individual, you've excluded them, and outlining the reasons for the exclusion.
So can parents set up like some kind of a trust or something prior to passing that will take care of that? Because what if it's millions of dollars? You don't want your 18-year-old to be left with millions of dollars, and then that's a disaster looking to happen.
Exactly. Yeah. So whenever we have minor children, usually a trust-based plan is going to be more advisable because we want to make sure that we can specify exactly who is in charge, not force those assets to have to go through a court process for the child, and really make sure that the right person is guarding those assets until the child is an appropriate age, usually not 18. Usually when they're a little bit older and more mature, they've gone through, a few more years of brain development, and they're better able to make wise financial decisions with those funds.
This is Kelly Broaddus with Broaddus Properties Group, 928-606-6749. We look forward to serving you. Thank you so much.